morning, and we'll start today's discussions. Today we would like to actually discuss DGPSI Lite, the Lite version, and then we will have a discussion on some case studies. And after the break, we will also have a discussion on the DGPSI full version. So it will be some way tying up with whatever we have so far discussed. Okay. Now, we have already discussed that the DGPMS is a framework which is built on the DGPSI as a implementation or audit framework. And we have two versions of DGPSI, which is DGPSI Lite, which is a compendium of 36 compliance specifications. DGPSI Full is having more. Okay, so DGPSI Lite is a simpler version. Basically, we thought that for MSMEs and others who are only interested in being compliant with the Act and not much worried about improving their data governance, DGPSI Lite should be sufficient. So therefore, this actually focuses almost entirely on the Act. Something like a specific section, and there is a need for compliance kind of a thing. And if you are able to go through this, of course, there are 36 implementation specifications. It is not necessary to have 36 different policies. We can combine a few, but maybe ultimately you will still. In fact, in one of the cases which we worked on, we were able to actually say about 31 different policy documents we listed out and said that this is required for filling up the gap. So if not 36 different policies, at least about 20 policy documents will be required to be compliant fully. But the implementation specification list has been given more or less going into the requirements of the Act. For example, if you look at the list which is presently visible, we have given a reference section of DPDPA, and then within that section, sometimes there will be multiple requirements. Okay, so for example, if you take section 4, Section 4 simply may say that no company should process data without legal basis, something like that. So the first requirement is to establish whether an organization is processing the personal data for a lawful purpose. Say, even if you go to GDPR, the 6 principles start with the lawful basis. When you say lawful basis, the lawful basis may be applied to the processing, where we say consent should be there or legitimate use is there. But Indian law also says that the processing itself should be lawful in the sense that the activity of the company should not in any way be unlawful. Unlawful means that it is illegal in any particular act. So the processing should be lawful from the company's point of view, and it should have a legal basis. Both needs to be established. So the section 4 talks of 2 ways of establishing the legal basis. One is the consent and other is the legitimate use. So while we look at the establishing of the lawful purpose, first of all, an organization needs to understand where all in their organization personal data is being processed. So therefore, one of the first things which will have to be done is to have a brainstorming discussion with senior executives so that one can develop a list of processes in my company where personal data is being used. Okay, so preparation of this is similar to your ROPA in GDPR, you need to actually understand which are all the processes in my organization where personal data is being used. See, business people will know from their own, say, work environment, where all they are collecting personal data, which the CISO or the DPO may not even be aware of. Okay, HR, of course, is one visible department where everybody knows employee data is there. But there are also retail departments in many organizations, but including manufacturing companies, where the retailer, who may be actually a corporate showroom or maybe an independent person, he will be collecting personal data of public as part of his activity, and the responsibility for that obviously is the company. So we may or may not have visibility to all the activities of an organization in all corners of its activity. Therefore, the first important aspect is to get all the top executives of the company who are heads of different functional areas and tell them that this is DPDPA, these are the things. Maybe there will be a separate DPO, but each one of you need to tell me where you process personal data. Are you collecting personal data? Are you processing it? Are you transmitting it? Are you deleting it? Of course, they will say, what is personal data? We have to explain to them about personal data as applicable under DPDPA and tell them that this is not GDPR data. If GDPR data is there, there is a separate division which we have to handle. We are talking of personal data from which a data set from which you can identify a person, and that data set has been generated within India, and it is perhaps being processed in India also. So such data, if any of our people are aware of in the organization, I think that is something which needs to be noted. Now, when we say consent or legitimate use, we need to actually document even legitimate use, in the sense that we cannot simply assume that a particular process comes under legitimate use. Okay, or somebody may say this is exempted. Okay, even if it is exempted, even if it is coming under legitimate use, there has to be a document which says that this is supported by legitimate use because of so and so section so and so. Otherwise, every process has to be supported by consent. Okay, we should not, we should almost consider consent as the mandatory requirement, and everything else is an exception. Okay, so the framework will, of course, only say, give the top line requirement, establish the legal basis either as consent or legitimate use. Beyond this, how it is to be done is the implementation which you have to structure, and that is where a DPDPA implementation consultant may be of help to you. The framework, of course, will not go beyond this into templates. Templates will have to be developed on a case-to-case basis. Now, so this is the example of how this framework talks about one particular section. Now, then similarly under section 5, develop appropriate notices indicating the types of data collected, purpose of collection, details when the purpose terminates, and so on. Each process has a specific data need and a data entry point. See, this is where we have been saying that collect the consent to the point of where the data principal is trying to avail the service. Instead of collecting a consent as an omnibus consent for some 20, 30 processes, it is better to actually present the notice just when a person says, I want to avail this particular service today. Okay. Then it will be possible to actually have his attention on what you are writing in that notice, and that notice can be as per the format which the Act has stated, which is starting with we are collecting personal data for this particular purpose, and this is the list of personal data which we are collecting, and this is the period up to which we intend retaining this. These are the processors to whom are types of processors. You may not give the name. This whether it is being processed in-house or whether it is being processed with outside processors. All these things which you need to actually communicate to the data principal, you can do, and do this at the entry point of the data so that the person will be aware of what he is giving permission for. Okay. The notice should, as we know, indicate the manner of exercising the rights with the links to various additional documents, and also the manner of making a complaint to the data protection board. And it should also make provide the information regarding the availability and the manner of invoking grievance redressal mechanism. So these are all the detailing of the notice. So one policy for issuing the notice will have all these things, but there will be multiple notices. And of course, notice should be made available in the languages. Today, that is not a very difficult thing because translation online is becoming much easier, and you can use Bhashini, which is a government-supported translation service. And there are many other tools also which can be used. Now,
Sir,
yeah.
sorry, I have one question here. Instead of we saying 22 Indian languages for all concerned, can we, or notices, can we say that local language plus 1 or 2 languages plus English?
I am personally of the opinion that it is not going to be difficult to provide all the 22. Okay. The law,
Okay.
I mean, interpret strictly, it says that you have to give that option to the data principal. Now, even if you are in Bangalore, maybe you know only Tamil, maybe you know better at least. Okay, you may know
Correct.
English. And when it says any other language, we will be happy if you give it in Kannada. But why should you prevent somebody who is a Telugu person or a Tamil person not have his version? So how do you choose these 2 additional languages? Can you say neighboring states or something like that? All that is not
Correct.
essential.
Yeah.
Now, of course, you may say Bihari or Manipuri, I don't know, or something like that. So that's why I'm suggesting Bhashini as a government-supported this thing. And of course, most of the AI tools today automatically do a good translation. And if in your organization, if there are people who know that particular language, you can always ask them to vet that this thing separately. Okay, but translation can be automatic. Validation of the translation, you can try to get it from somebody who knows the language. I prefer that you provide that drop-down menu in which let the person be happy to take it in any language. Today, even the browsers provide that translation service. Say that browser page is being translated. Google Translation is not considered to be very good.
Correct.
So Bhashini people at least say that they are much better than Google. I would say, for example, you said these 2 or 3 local languages, which essentially means that you are having people within the organization whom you know are able to understand that language. You can just ask them to vet this translated version and just hold it as part of your due diligence requirement. You get an automated translation, but as a part of due diligence, ask some of your colleagues to just go through it and confirm whether there is no glaring mistakes. Okay.
No, but my question is, if we don't provide 22 languages, will there be a penalty or something that will be imposed on organization?
It is left to the discretion of the data protection board. See, data protection board is not interested in penalizing everybody. It is not like GDPR supervisory authorities who have considered penalties as a revenue generation for their government. Here, I am expecting the data protection board to be very, very lenient. Okay. Initially, they will only try to educate the companies on telling them what they are doing wrong and try to correct it. That's why there is a voluntary undertaking process also in our system. Okay.
Okay.
So
Okay.
I don't think they will jump into penalizing an organization
Sir,
because not given 22 language translation or something like that. Yeah.
just to answer him, also as we are aware, it says data fiduciary shall give the data principal the option, as you said, one, right, to access the contents of the notice referred to in the subsections 1 and 2 in English or any language specified in the 8th schedule of the Constitution. So that R is there. And you should, as you correctly interpreted mentioning that if you are in Karnataka, better you give English, Kannada, and if need be Hindi. That's all. Like that only. I think R is there.
I know that is your view. My view still is that.
I understand.
Okay.
I am reading like a lawyer R class. That's all. Thank you. Yeah.
Okay. When you say option,
Yeah.
okay, then you have to give me an option of one of the R's. Okay. It is my option, not the company's option, the data principal's option. Okay. Anyway, I think it is actually not a very difficult thing in terms of implementation. That is what I feel. Okay.
Okay, sir. Fine. Fine.
Yeah. Beyond that, I also told that you don't think that DPP will be interested in putting heavy penalties for such things. But they may ask you, why are you not giving it? Okay. Have any of you checked Bhashini translations? If not, you can.
No, I have not checked.
Okay. And anyway, you try to translate whatever you have already drafted in English and then check in the language in which you are aware of. And as I told you, as a due diligence, ask somebody who knows that language to confirm whether it appears to be okay. Okay, that is the detailing of the process. I'm not going into it here. See, our framework simply says this. Okay, notice should be available in 22 Indian languages with an option for the data principal to choose. Okay, it is not I am the person who is choosing it. Ultimately, the entire thing is to be read in the light of the options from the data principal side. Okay. Now, when the Act says that consent should be free, specific, it requires an affirmative action, signifying an agreement. That is where we discussed yesterday about the signature or say authentication aspect. So with all that, you actually do this, create this inventory of personal data. Most of the other frameworks will simply start with mapping of personal data. We are actually arriving at that mapping through a process inventory. And from the process inventory, we are identifying what kind of personal data is required for that process. And then we aggregate that. There are certain advantages of this process because instead of looking at the entire enterprise in one long view, we are actually focusing on individual processes and say whoever is the process owner will tell him that you are responsible. So please tell me what kind of data you are collecting, processing, what kind of data you're holding for the last 10 years, 15 years without deleting, all that only he knows. Okay, we want that clarity to be available when you create an inventory of personal data. Okay, and when you make him responsible, he will be perhaps looking at it more in depth. Otherwise, there will be some places where some old personal data will be there, which is not being used, and everybody forgets that, and it will be there within the company, but not useful. But you are carrying that liability. That should not happen. Okay. Then establish the process for using consents received through consent manager. This is an option which you have to provide, whether there is a consent manager or not in the immediate future. When they come, you should be ready with that. So you may have to have a blanket policy for handling the consent manager, because what is the consent manager process? You have to start with an accreditation advice from the DPB. Okay, so on the DPB website, when somebody appears as an accredited data consent manager, you should recognize that. And then you should make the provision of accepting it from that particular thing, so that first of all, the first API has to be made available, and we hope there will be only one API which should be able to take multiple consent managers. So when the first consent manager is accredited, then look at the API which he has developed, and that should be the interoperable platform. And therefore, if you implement that API, tomorrow if the second consent manager comes, the same API should work. Okay. I hope there will not be a situation where you have to have multiple APIs, one each for consent managers, but still you have to test it out. So you have to implement the API, test whether it works with that consent manager, and then put it in your drop-down menu. That is what you have to do. Then data principal may use it or may not use it. That is something which may happen later. So that is the establishment of a procedure for receiving the consents from the consent manager. Then ensuring documenting of the consent for prospective collection of, say, why we say prospective collection is there is a legacy collection and a prospective collection. So when you are talking of the prospective collection, the new consent will come in, and then that consent will have to be tagged properly with a number, etc. And then as far as the legacy data is concerned, there has to be a process again here. Here you are talking of identifying the legacy personal data of people, sending them notices, receiving the reply. Some replies will be positive, then put them into the approved list of data principals. Some will be negative, that will have to be deleted immediately. Some you will not get the reply, so you have to put it under some suspense and then take a view about it in consultation with your organization. So the legacy consent gathering is itself a mini process, okay? Whereas the new or prospective collection is linked to the data entry points, creating a privacy notice, putting it there, collecting it, okay? So there is a slight difference between the two ways of collecting. So you have got actually three systems of collections: collection for prospective data principals, collection from legacy people, and then the consent manager. So all the three you have to generate appropriate policies and procedures. Okay. So when you say consent management system, it should have an ability to present the notice at the data entry point, collect the consent with evidence, which is either a digital signature or a metadata collection or whatever is that, store it with a unique consent ID. Every consent has to have an ID. Associate that consent with whatever process ID to which it is related. And the consent itself determines the data minimization, retention minimization, data quality, and so on. Say, unlike in GDPR, our laws does not specify exactly that data should be minimized or etc. It is all built into the purpose-oriented collection. And as far as the data quality or accuracy is concerned, our law says that if you are using it for either the disclosure or for automated decision making, then you need to keep the data updated. Otherwise, it may not always be necessary. Okay. That is, if you have used it once in the past and you are not going to use it again, then you don't have to go back to the data principal who is actually, let's say, take a hospital, you have got your past patients. You don't have to go back to them again and again if it is just an archived data. Okay. Only if you are using it for disclosure or for automated decision making, then this updation will be mandatory. Okay. Then the process owner itself in our system has the accountability. So the consent management system has to actually determine who is going to be accountable for getting the consent and documenting the consent and retrieving the consent when tomorrow some rights are being exercised. So these are some of the things which we have not specifically listed here, but you need to develop that as part of the program. Then establish a policy for legitimate use. with monitoring and control. Why monitoring and control is required is today something may be legitimate use, but things may change, processing requirement may change. So there needs to be some kind of a continuous monitoring of all processors where you have not obtained consent, but you are relying on legitimate use. And I feel that you need validation of that from the top management so that the DPO does not take this decision entirely on his own. Now again, the model implementation specification 13 says ensure that the systems are in place to enable compliance with all aspects of the act, including new notifications that are issued from time to time. So the implementation is not a one-time implementation because things will be changing, particularly in the first few years. I am expecting lots of changes will happen. First of all, the government itself will be coming up with new notifications. DPP may come up with new notifications. There may be some case laws developing. So somebody in the organization needs to keep following these changes. It could be the legal department, it could be the DPO, it could be an external consultant whom you appoint to help you in monitoring this. But this is definitely something which is required. Okay. So for establishing this legitimate use, the process register itself you can use, and each process will have to be supported by a document which is legitimate use. And regulatory watch needs to be established to ensure that you are able to understand what changes are happening from the government side. Then as far as the contracts are concerned, every data processor has to be supported by a contract. In fact, you should say that every processor will have to have a processor ID. We actually suggest a register of processors in addition to register of processes. Okay, so there are 20 processors, and each process may have 2 or 3 processors. So an organization may have 100 processors. So you need to create a register of these processors. And for these processors also, there should be an ID, which are the processors to which they are providing the service. And then you need to ensure that the person who is in control of that contract from the other side, you should have a record of that. And we suggest that the CFO should say that no payment will be made to any contractor unless there is a valid contract, which is current, because it might have actually expired also. So this is what we say is required here, ensuring the availability of appropriate contract. Okay. Then establish technical and organizational measures. It is an omnibus requirement. It is itself a subsystem, and it includes all other measures. Okay. So this is the model implementation 15. Okay. Any questions up to this? This model implementation specification 16 is regarding the security. Again, this is a subsystem. You can check rule 6 under the DPDPA rules, which talks about tokenization, pseudonymization, encryption, log monitoring, etc. So that has to be applied for the personal data. Okay. Now, the framework says you have to establish a suitable system. What should be that system? You should actually work out in consultation with the consultant. Then under implementation specification 17, which corresponds to the section 8, establish appropriate policy to identify, investigate, respond, and report a personal data breach, because this is the incident management system, which has to ensure an appropriate incident identification, then reporting internally first, and then evaluation, confirmation that it is a data breach to be reported, and then report it to the appropriate authorities. then how do you actually respond subsequently when there is a directive? All this should be part of this implementation specification 17. Now, 18, ensure data retention is linked to purpose of collection. And probably you need to develop a data retention policy. Now, again, how do you develop the data retention policy? You have to actually go back to the process controller and say, in your process, you are processing personal data. Tell me how long you need this particular data. Now, if it is a single purpose consent, then it is to be processed once, and then you don't have to keep that information, and that has to be either put into the archive if you have any other need to retain the data. Otherwise, it has to be purged. So the data retention policy at the enterprise level has to be again drilled down to the process level, and the view of the process controller becomes most important, because he may think that he wants this data to be there for 3 months. You cannot override him and say, no, you cannot have it or something like that. So there needs to be a consultation with the process controller and then determine what is the data retention of the data elements required for the process which is used in that particular context. And then you can separately consolidate it and call it as an enterprise data retention policy. So maybe sometimes some data is required for process 1 for 3 months. Same data may be required for process 2 for 1 year. So you need to ensure that the data retention takes into account the process ID from which you are determining the data retention time. Then, of course, the maximum out of that becomes the time after which it has to be purged. But before that, if process 1 requires this data for only 3 months, then the access to that data, which continues to be in your data store, needs to be taken out from process 1. It may continue for process 2 until that requirement is satisfied. So these data elements as a subgroup of the data will have a different data access control, different data retention control, and if you are using a software for managing all these things, ensure that whatever we are talking of here under implementation specification number 18 is being addressed by that particular software. If the software says, I cannot make all these distinction, I will keep all the data for 5 years, whatever you want, you do it, then we are only talking of manual supervision. So that is where I'm saying that some of the consent management systems today are yet to mature to the requirement of the DGPSI, which essentially means requirements of DPDPA. Then under 19, publish the business contact information. So this has to be done by the person in the organization who controls the information on the website. Many times the HIPAA compliance officer's name is not there on the website. The grievance officer under ITA 2000 is not available. So like that, DPO also, his contact may not be there in the website. That needs to be ensured. Now, 20, establish an appropriate grievance redressal mechanism. This again is a subsystem which has its own detailing of how do you receive a grievance. Then once you receive the grievance, are you acknowledging it immediately, which can happen immediately, okay? Giving a ticket number or whatever is that. Then transferring that grievance to the appropriate person in the organization, and that person taking necessary steps. All this is a subsystem of grievance redressal which you have to develop. And if grievance redressal officer is different from the DPO, the coordination between the two also needs to be ensured. Grievance redressal has the possibility of getting into mediation, and I think most of the companies should have a mediation as a mandatory requirement. You can have an ombudsman introduced before that. An ombudsman is a person who is an external person, respectable person, Sometimes some disputes are referred to him, and if he gives his view, maybe the data principal also may accept it. So you can try that. So first of all, you try negotiation by the grievance redressal officer or the DPO or both with the data principal. Then suggest that can we go for an ombudsman? So and so is our ombudsman. If he agrees, then ask the ombudsman to give his view. If the ombudsman's response is not acceptable, then suggest a mediation. If mediation also is not possible, then of course the complaint to the DPB will have to happen. So that entire system is covered by one implementation specification number 20. Okay.
Navi sir,
Yeah.
yeah, very good morning. I have just a question regarding whenever a grievance is received by a grievance redressal officer or something, is it mandated that he must respond within 72 hours to that query?
No, it is 72 hours is for data breach notification. Here,
Yes.
you say acknowledge immediately. Okay. Then within 30 days, try to resolve. Okay. Now, as of now, 30 days is considered as a reasonable time, but sometimes you clear it off as quickly as possible, and sometimes you may not be able to resolve it even after 30 days. But grievance system should be activated as early as possible. Okay. So 72 hours is different. Here only 48 hours sometimes in Information Technology Act we talk of, but that is all for initiating a grievance redressal process. Nobody expects you to resolve a grievance within 24 hours or within 48 hours or something like that. Okay. Better acknowledge immediately and set in motion the grievance redressal process as early as possible, and try to resolve it within 30 days. If so, you have to mention it in your grievance redressal policy. Say, in the grievance redressal policy, you have to specify that we will be trying to resolve it within 30 days. So it is a self-declared time limit, which should be reasonable. Okay.
So basically, if I'm not able to solve it within 30 days, then I have to give an explanation so that I need more time.
You have to document. You have to document that at the initial stage, you are only discussing it with the data principal. You are telling him that we are still examining the system and we need more time or something like that. It is for him to accept your explanation. Otherwise, he has to go to the data protection board as an appeal to that decision. Your decision not to give within 30 days may be taken as a refusal, and he may make a complaint. That option is available to you. Okay.
Thank you, sir.
Yeah. So if say as far as the security is concerned, we would like to think that each process you can do a separate risk assessment, and again you can always take the assistance of the process controller and his views. This is some of the detailing which you can think of so that your implementation becomes more, you can say, effective. Okay. Then, so whether it is for data retention or for anything else, you need to have a subsystem which handles that. Now, 21, in case of minors, we have an age gating process. Age verification is required for every data principal. It is not for only those who declare themselves as minor. So the first check is that I am not a minor. Okay. And if somebody says I am a minor, then the question should follow, who is your guardian? What is your date of birth? So when we say verifiable consent, it has got all these three verifications. Of course, I'm not saying that you should also verify whether a person is a guardian. See, somebody says I am the guardian, you are not going for natural guardian. Somebody says I am the father, you are not asking him, are you the father? Okay, give me proof. But if you are using Aadhaar of the minor as a validation, probably there itself you will be finding the name of the guardian, whether it is father or mother, and I think you can use it. If for some reason you find that the surname of the minor is different from the surname of the person put as guardian, then due diligence expects that you try to find out who is this other person. Is he the real guardian or not? This is the aspect of due diligence. See, under the DPDPA rules, it leaves it to the discretion of the data fiduciary as far as this age verification and other things are concerned. So that is actually more onerous because you have to take the responsibility for that. For the minor, of course, date of birth is required because after the attaining of the majority, you may have to switch over the consent. Okay. Now, then 23. Okay, and this behavioral monitoring and targeted advertising is one of the controls which you have to put for minors. Within the period, they remain as minors. We feel that by classifying the information separately as minor information, you are in a way capable of putting these additional controls to only that class of information. This is why classification system supports the implementation of this implementation specification 22. Okay. Then we come to this significant data fiduciary. In fact, this is something which has to be done quite early. It has to be prioritized that right at the business impact assessment time, you should make a policy statement whether our organization is to be considered as not a significant data fiduciary. See, if you don't have this document that I am not a significant data fiduciary, then you will not be justifying the non-appointment of a data protection officer or a data auditor. So we suggest that you get the management's approval also for this basic statement that whether we should consider ourselves as significant data fiduciary or not. And it is always better to err on the safe side. Even though you are not a significant data fiduciary, if you want to appoint a data protection officer or the data auditor, it is always better. Then 24, if an organization is an SDF, of course, you have to appoint the data protection officer. Then the question of what qualification, credentials are required. Okay. Then 25, again, if it's a SDF, additionally independent data auditor is required and periodical audit is required. So 24, 25, 26, they all relate to the SDF categorization of the organization. Now, we have stated that when you have a process-wise enterprise, bifurcation, some processes may be critical, require an SDF kind of an approach, some may not be. But organization as a whole can have only one designation, either an SDF or not an SDF. So if there is any one process in which you feel you are a significant data fiduciary, obviously the organization will be declared as a significant data fiduciary, though you can prioritize your security and other implementations based on individual processes. Some processes where not much of control is required, some processes where additional controls are required. In terms of encryption and other things, maybe there may be some processes where you may not worry much. Okay, whereas in some other processes, you may have to take into account. Okay, then we have a set of implementation specifications related to the rights management. That is section 11, which talks about the access right. And when you have the access right, then you need identity verification of the person exercising the right, then extract the past consent wherever you have stored, validate the person and with reference to the consent, and then send the summary, and then document the whole process that a particular person asked for this information, we gave this information. Okay, so if there is somebody who makes it a habit of sending you requests again and again without reasonable cause, then you may have to look at the possibility of charging him for such frivolous complaints. So suppose otherwise somebody may keep on sending you every day, give me a summary, because for him it is only as easy as sending an email. So if you feel that somebody is doing it for harassing you, then at some point of time you may say, no, I am not going to give it. If you want, you complain to DPB, because if he complains to DPB, then under the penalty clause, there is one penalty of 10,000 rupees for frivolous complaints. Okay, so he will not be able to go there. So these are things which you have to build in to the data access management subsystem. Okay. Similarly, when you talk of the right of correction or deletion also, the same process of identity verification, etc., will be there. When you are looking at erasure, better check with your legal department and document their consent before anything is recommended for erasure. In the case of correction, there may be certain cases where you may not agree for the correction. So then a dispute may arise, and be prepared to go to the DPB for that particular purpose. Then reference to section 13, we feel that you should have some process by which you inform and educate the data principal on the existence of the grievance redressal mechanism, on the right to nomination. In fact, both of which you have to have separate processes and give hyperlinks to the consent notice itself. Okay. Then also keep them informed about the duties under the Act. There is, this is not mentioned in the list of things to be mentioned in the notice, but it is always better that apart from these rights, you also add a link to the duties of the data principal, so that let him be aware that if he makes false complaint or impersonates somebody or something like that, then he has to be, he's open for some kind of a penalty on that. Then if you go to 32, ensure keeping track of directions from the Data Protection Board. These directions come after an inquiry has started. Okay. Earlier, I said that you have to continuously monitor the changes in the government policies. Here, we are talking of an inquiry, and which means it is now in the hands of the grievance redressal officer. That grievance redressal officer, after resolving the grievance at his level, if he finds that a complaint has been filed with the Data Protection Board, he has to keep tracking what happens there, and it may result in some directions. That directions may have to be implemented not by the grievance redressal officer, but by the DPO in the systems. But that has to be, there has to be a system to manage that directions. Okay. Now we have discussed some of these requirements, for example, in the nomination and other things, what subsystem should be there. So let me keep it away. And as far as this monitoring the grievance, and even earlier, DPPI provides service to their corporate members as a DPPI mentoring service. If that is considered useful, you can always keep some channel open for external assistance. Okay. Now, implementation specification 33 is about the exemptions. Again, like this legitimate use, exemption is also something which has to be interpreted. And therefore, if you are processing any data under an exemption clause, please get your legal department validate that through a policy document. If you are a process controller, I would advise that you say that I will not process the data without consent unless the legal department gives me a confirmation that this process is on a legitimate use basis or it is on certain exemptions. Okay. So if the marketing department is insisting on that process and wants you to be the process controller, you have to tell the marketing department, please get me the validation from the legal department. So that way the process controller can ensure that he is not processing any data without appropriate legal sanction. Okay. Then 28, establish measures to promptly receive and respond to communication from the Data Protection Board. We don't know how they will establish this. Like today, CERTIN has got a requirement that every CISO of the organization has to register themselves with the CERTIN. So here also they may introduce tomorrow a system where every DPO has to register with the Data Protection Board with his email so that communications can be sent to them. We have to watch and see how this has to be implemented. Then establish measures to receive directives that we said, and also the voluntary undertaking process, because in voluntary undertaking, it is a decision of the top management. That is, you are actually, it is like plea bargaining. So you are accepting some mistake has happened and submit to the Data Protection Board that we are not contesting your inquiry. We would like to discuss with you how we can voluntarily comply, so that we will request you that don't put any penalty, then subsequently it is left to their discretion. So this decision has to come from the top management as a risk absorption category. So after, when something reaches this stage, the governance committee may have to work at the highest level and then give the directions within the organization to the DPO. Okay. Then structuring and proposing the voluntary undertaking itself is a very big expert activity. You may need external consultation also for that. So these are the 36 implementation specifications which the DGPSI Lite expects. And what I expect is that please develop a conviction that DGPSI Lite can be used as a framework, even if nobody else says I have used DGPSI. Because many people may say I have used GDPR. Okay, so it is for the first time that you are coming across this. So please go through it yourself, develop the conviction. We believe, of course, DGPSI is the way to go. Okay. So if there are no questions, I would like Ramesh to now take over and start discussing some case studies. Okay. Any questions?
Sir, I have one question.
Yeah.
Sorry for that. See, for organizations like us, majority of our data will be internal data. When I say internal data, it is more of employees' data and so on. The processes also will be more of employees' data. Very few will be customer data. Now, for me to document the purpose, more likely it will be a legitimate purpose, will be for employment purpose or contractual purpose. Only these two will be the majority of my purpose that I can document, right?
Correct. Correct.
Okay. No, I was trying to get an understanding on that. So
in the HR process, what happens is you try sometimes process data before a person becomes a employee. So
correct.
there's always a gray area where is he an outsider whose data you processed, and then he becomes an employee. So better have clarity within the organization and supported by policies, because your HR process itself, there may be multiple processes. It is not one single process. No, the HR manager may be one, but
correct.
You have multiple processes, and each may be big enough to be called as a sub-process. So
yes,
better, so for example, your background verification agent, okay, somebody, he's a processor. Okay, you have to have a contract with the process. So there is somebody who is handling this relationship with the background verifying agency. Okay, so you have to see whether what you are doing there is covered entirely under the legitimate use, whether it all comes as part of the employment process. So it's better as a process manager, ask for some documentation so that there can be some internal discussions.
Yeah, that's right.
Okay.
Fine, sir.
Sir, I have sorry. Sir, I was just thinking, in a data fiduciary or a significant, I have a contract with a data processor. But after, say, about 3 to 6 months, the process is over, I sever the contract. In that case, some of the data is with him. Now, what happens is he is giving me a purging certificate. So how reliable is that? And because I am at risk because that data is misused, then ultimately I am liable. So how to go about, and your views, please.
Your data processor contract should have a data audit permission so that you can conduct an audit on him, and also to give an appropriate assurance about the data purging. Okay. Now he has to give evidence that the data has been purged, but it is as good as the reliability of that particular person. You can do nothing more than that, except that there will be an indemnity clause in your data process contract. And under that indemnity, if something goes wrong subsequently, the loss will have to be borne by him. One. Second, it will become a breach of trust. Okay, it is a cognizable offense. Okay, and then it also is a breach under Section 72 capital A of Information Technology Act. So in your data processor contract, make a mention of Section 72 capital A of Information Technology Act and say that you will be liable under Section 72 capital A in case of any breach of this particular agreement, because people may not remember that there is a separate act. Okay, so that is all you can do. Beyond that, of course, if he tells you a lie and then continues to use it, and subsequently if there is a data breach, then the question of determining whether the data breach happened from his end or your end will be there. And another thing is, before you transfer any data to an outside thing, wherever possible, use pseudonymization or some kind of tokenization so that the data processor does not have the real data. If that is possible, please implement that kind of a thing. So we call that as a pseudonymization gateway. That is, before you push the data, you actually do some kind of a jumbling of the data in such a manner that the process itself will not be affected. We are talking of, when we say pseudonymization, it is item to item pseudonymization. Name will be changed into another ASCII character. Number will be changed into another number, kind of a thing. If you use normal data masking or something like that, the processor may find it difficult to go through the processing, which is presently geared towards processing of fully identifiable data elements. Now, each data element, if you are pseudonymizing separately without changing the structure, then his process will not be affected. But if at all any leak happens from his end, the possibility that that data leak does not affect the real data owners is possible. So use pseudonymization gateway with all data processors wherever feasible. And I think it should be feasible in every case. Today, we are even talking of homomorphic encryption, where you can process the data in an encryption mode. So I think you should explore those possibilities. Then only your risk will be less. Otherwise, every data processor is as good as his word only.
And this, along with the indemnity clause, will work as a good deterrent. Both
Yes.
of them, sir.
Yeah.
Yes. Thank you so much, sir.
Okay.
Sir, one point from me, sir. You are referring to Section 72 of ITA with reference to the disclosure of capital A of ITA with reference to disclosure of data. This Section 72A applies only when the data is intentionally leaked out.
No, not necessarily, because right now, see, earlier 72A was a clause in which there was a penalty in terms of imprisonment. Is it not?
Okay, sir.
But now it is not there. That is, after they decriminalized some of the sections, the Janavishwas bill.
Yes, sir. Yes, sir.
So this could apply to negligent is a disclosure against the contractual requirement. That's all.
Okay, sir. Okay.
Also applies to, so also applies to accidental disclosure also.
Yeah, accidental disclosure is already defined as a breach. Okay.
Yes, sir.
Okay.
I will just read out this thing, section of 72 capital A.
Please,
Save
sir, please.
as otherwise provided in the Act as any other law for the time being in force, any person, including the intermediary, who, while providing services under the terms of lawful contract, has secured access to any material containing personal information about another person with intent to cause knowing or is likely to cause wrongful loss or wrongful gain, discloses without the consent of the person on the breach such material, then he will be liable to pay penalty which extends up to 25 lakhs of rupees. We are talking of a similar situation here, that after the contract is over, the data breach has happened. So the question is whether you can call that as recklessness, negligence beyond reasonableness or something like that. Okay, you may have to say that it was gross negligence.
Okay, sir. Thank you. Thank you, sir.
Okay. Yeah. Yeah, Ramesh, you can start.
Yeah,
we
yeah.
can come back to this later on if necessary. Okay.
Able to see my screen now, Navi, sir?
Yeah.
Okay. So, team, further to some of the case, we will discuss few of the case studies. Further to the continuation of yesterday, absolutely feel free, and we will also talk about one which I shared it with you yesterday. Now, see, there is one case study, JV Healthcare Trust. Just take your time, just observe what is this. I will also read it for you. JV Healthcare Trust owns a multi-speciality hospital and also a medical college. Disha Foundation, another one, nothing to do with the hospital here. The Disha Foundation is a global organization, has invited this hospital to conduct a special camp in its premises. Last week, there was a dental program happened at our office for us like that, right? Where several national and international volunteers of this foundation would get participated to organize everything, right? And also thousands of villagers where the camp is going to be held to attend the health camp, which includes a certain one general health checkup, diagnosis for critical diseases too, and third could be simple eye surgeries. 3 services they're talking about, 3 camp. All participants should be issued a health card for further treatment as hospitals who are participating in this health camp program and availing of insurance and other benefits, right? Several NGOs, pharmacies, students, they're all the stakeholders, please understand, of the medical college and also doctors who are volunteered for different services to assist the execution of this health camp project. The medical college intends to use the data collected for research at the medical college, right? Pharmacies are providing concessional medical, obviously they are going to hold the data, right? And supplies to JV, that hospital, and the Isha healthcare holders, they are going to avail some services. Interestingly, the JV hospital is certified for 27001 ISO and HIPAA, of course, because it's international also. During the discussions of the project at the board meeting, the DPO of the JV hospitals raises a concern about the DPDPA, what we are discussing, and its impact on the compliance requirements of the hospital as well as the trust and the medical college. List out the points of concern for further discussions. So, same thing. Look at yourself as a DPO and DPDPA in mind. What we need to really look at it. What kind of risks might be there? How we wanted to. Are you with me?
Yes, sir. Yes.
Yeah. And very quickly, I also wanted to share with you that Navi sir would be sharing, let's say, 2 assignments at the end of this program today, which you need to think about it and submit the assignment, and you'll also be getting 10% of your, the final marks from this assignment. So it will all help us to really look at various use cases, basically. Anybody would like to unmute and share with this? What would be that, like yesterday?
The first one obviously is the role.
Very good.
Okay.
Very good.
And second, there are multiple stakeholders involved. Like for example,
Oh, beautiful.
data is getting shared with pharmacies, NGOs.
Yeah. Very
Okay,
good.
so we will need to understand. We will need to do an DPIA because this data is being shared with so many people. We will need to ascertain in terms of the safeguards of the data in terms of how is it going. One is they are capturing the personal data, they're capturing the health data of people, they're issuing the medical cards and so on. The second thing is we have people who probably may not have exposure to the impact of that. They may not have the seriousness of handling the data. Like if I'm saying students, sometimes
Excellent.
students may not have the awareness.
Very good, sir. Very good.
Sir, can I
Yeah.
add something?
Please.
Sorry.
Sir, whether two things very important: security by design and privacy by design. Whether this has been implemented, whether where the data is collected, where it is stored, and in what form it is stored.
Excellent.
Correct.
And another very key thing, I think, who has got access to that data? Is it a role-based access, privileged access? What type of access you are giving to various people?
Very nice.
Thank
Very
you,
nice.
sir.
Very nice. I will just thank you very much. And just look, many other things what you guys said would be there. I'm looking at the first thing. Try to, Subha sir, please go ahead.
Yeah, I think ISO 27001 and HIPAA are not going to help because ISO is only a information security standard and not a privacy standard. And HIPAA is in any case a US law. So in any case, because the villagers in this case are Indian villagers, their data processing cannot be confirmed to be in accordance with the laws of the HIPAA certificate not going to help that. So neither 27001 nor HIPAA are going to help. So the DPO is very right in the sense that we have to look for number one, a privacy compliance, not an information security compliance, and that too privacy compliance that applies to the Indian situation, Indian laws.
Yeah.
So that has got to be conducted afresh, and one has to take cognizance that none of the two certifications are going to. They may help a little,
There
but
you are.
there'll still be gaps.
There you are. Beautiful.
Yeah.
Beautiful.
Yeah.
Thank
The
you.
other important thing is the privacy notice has to be clearly defined in terms of how the data has been used and so on. And because it is villages, we also need to ensure that the notice is in their languages in which they are able to understand.
Yeah.
And probably we also should emphasize, maybe more in terms of training, awareness, and so on for the villages, considering the background that they are coming from.
Great. Thank you very much. Really.
I
Sir,
have just one thing to add. Villagers represent a risk in terms of their awareness. So we
Yeah.
have to be careful when dealing with them. So additional layer of security and should be incorporated. So because their awareness is very less, because they unaware might give a lot of information.
Very
So
good.
that is, we have to be very careful regarding how we handle them.
Very
sir,
good.
a couple of points from me. It says some of the volunteers from the international volunteers.
Yeah.
So we have to take care whether the data is any transmission of data abroad or something like that. We have to see. And another point is, are there any minor participants?
Beautiful.
That also we have to. Of course, this doesn't say whether there are minors or all are other than minors only. But when there is a health camp, there is every possibility that minors will also participate.
Absolutely.
There can also be person with disability also.
Yeah.
Like it's minors and disabled persons. And second thing, sir, that this third part is, I think this JV Healthcare Trust has to see that whether they are DPDPA compliant or not.
Yeah.
That is also required, sir.
Very good. Thank you very much, all of you.
One more is that are there any formal agreements between JV Health and Disha and the vendors?
Excellent.
They're like the vendors, whether any DPA clauses are there with them, or at least if it's not a long term, there will be some kind of a written arrangement between JV Healthcare and all the other participating entities, so that they have
Yeah.
they comply with due diligence requirements on
Very
their
nice.
side.
Very nice, Subhash sir. Very nice. Somebody was
So
telling
one more
last
thing.
point. Yeah.
Sir, Rajkumar here.
Yeah.
So I think most of the points were covered by others. So how I approach is first I will see who are all the parties involved. Okay, so first is JV Healthcare, Medical College, Ditha Foundation, and villages. And how I see is by whom it is done. So which is done by Disha Foundation, and for whom it is done is the JV Healthcare, and on whom it is done is villages.
Yeah.
This
Very
is how I look into it.
Very
And then the points that
Yeah. Others.
my friends in
Yes.
the call said, how secured it is, what the contract is, what kind of information is collected, is any of the data being, say, personal data, or the what data is collected from the villages? Are they collecting the Aadhaar card, ration card for them to do any kind of diagnosis eligibility? And then also, is that shared with the medical college or with the pharmacies or anybody else?
Great. Great. Thank you very much. Thank you very much. All of you. Great. And one bullet really, what I think Subhash sir talked about. This we need to keep in mind. ISO 27001 or even 27701, which it talks about the PIMS, as we all know, or HIPAA or any other framework, right? By adhering to it as of now, question, would it be sufficient for me to implement DPDPA, right? We need to be aware. Be with me, as we all know, DPDPA is unique in its own kind. Many of the concepts which we are talking about in DPDPA is not covered in any of the laws, 140 laws, what we are talking about as of now. For example, consent manager, rights, duties of the data subject, nomination facility, right? Grievance redressal mechanism, especially. These are all not there in any of the laws. So let's be very clear. And having said that, he also covered, I was waiting for him to cover that. He covered it nicely, that these implementations obviously going to help you and me to a certain extent, definitely. Because encryption is encryption, right? Whether it's data at rest or data in transit, backup is a backup. Whether you do it daily or do it based on the sensitivity and criticality of the data, business continuity is business continuity, irrespective of any law. So the concepts, the technological measures, what you're talking about, right? 50 plus controls, to be precise, 37 of your technological controls of the 27,000 would help you and me, definitely. However, it may not be fully adequate enough. That I think it has to come out very nicely. So that's exactly the same way I am trying to approach the problem. Identify all the stakeholders involved, starting with the JV hospital, the trust, the medical college, the Disha Foundation, national and international volunteers, thousands of villages you and me do not know. Insurance company comes into picture, multiple NGOs comes into picture, pharmaceutical comes into picture, students as a volunteers are coming into picture. Oh, beautiful. Yeah, big multi-dimensional we are talking about. And interestingly, all these bulleted guys are going to be private to the data, what is going to get collected throughout that camp. So we need to be very careful. What are all the activities? Basically, the three important services, what they are trying to offer. Look at it, simple eye surgeries. These are all the sensitive data. Even though DPDPA doesn't talk about different varieties of personal data, it's only talking about personal data in a digitalized form, not like GDPR, where we have a definition of a sensitive data. In HIPAA, we are talking about PHI, protected health information. But with our experience, we know that this is going to be very, very sensitive data. Diagnosis for critical diseases. So again, big problem. I need to have a strong measure. What is that we are going to, where are we going to use the data? The medical college, it's very clear from the case study, intend to use the data for the research purpose. Oh, beautiful. Then you and me need to apply DPDPA, whether it is going to get exempted or no, we need to be aware of. Pharmacies are providing the concessional, that means they are going to have that entire data based on certain criteria, right? whatever they wanted to apply to provide some kind of concession. So we need to be very careful. And the current state, as you and me know, that hospital, at least I'm happy to hear, they have some measures in place, right? As a DPO. That means I need to do probably gap analysis of from here to my DPA, what I need to take care. Now, let's take that key stakeholders, whether it is a JV hospital, medical college, the stakeholders, we need to be individually, are they compliant? I think Radha sir talked about it. Are they compliant? Because they are all coming together. If they do not have an awareness, it's going to be an issue for you and me. Are they getting exempted? And whether they have got that exemption facility availed, we need to be very clear before even signing a contract with them. Have the roles of the organization been identified, because they are handling sensitive data? So I'm looking at volume of the data, thousands of villagers, right? And whether they are a significant data fiduciary or whether they are a joint data fiduciary, because many of the stakeholders are coming together. If they have identified a significant data fiduciary, are they compliant to the requirements of DPDPA, which clearly says, starting with, you need to have a DPO in place based in India. So we need to be aware of whether each one is collecting the data separately at one point by the Disha Foundation, and it's going to get shared by them. This is very interesting, right? Each one is going to have, or only one person as the entry point, and then that is going to get shared. At least one control, we have strong control. Whether all the involved organizations have got the respective contracts in place. Already one of you talked about it, data processing agreement contract we are talking about with the liability clause. Somebody asked, I think, right, about background verification. This is the time for each one of us to relook at that existing supplier contracts in the organization to cover, if you are not covered, let's say, performing audits at regular intervals in your customer's place, in your vendor's place. It has to come in, because just by hitting the purchase certificate, fair enough, right? But still, we need to have that kind of audit clause. Who would be the identified? This is exactly right. Even we are talking about non-disclosure agreement. Earlier, we talked about it in the earlier days. NDA to be in place as part of the terms and offer conditions of the employment at the time of employment. Fair enough. But today, we are talking about even having that non-disclosure agreement at the time of exit clause also, at least for, if not for the whole organization, at least for the senior and critical resources who handled my architecture, who knows my product design. I need to have at least for 3 years is what's the best practice. The same thing we're talking here. Verification of Disha health card, because each one is going to, based on this, some provisions, some obligations are provided in terms of concession or etc. Already, I'm extremely happy. Somebody talked about handling any minor data. DPDPA comes in. Verification of age, guardian. So we need to think from that direction. And because it's international volunteers coming in, I do not know international who are all coming in. What are the other applicable laws? Example, your UK GDPR or EU GDPR or California Privacy Regulation Act or Singapore and so on. So we need to be very, very careful, because we have seen, at least we have got a good experience in India, right? Yesterday, day before yesterday, just to tell you, I was in Vellore, that I don't know how many of you know, there is a golden temple. I just went for 1 hour. Believe me, I saw lots and lots of foreigners, right? In India especially. I was looking at the same thing, whether they are really DPDPA compliant, because they are getting their personal details getting registered at the counter, right? So we need to be careful. Moving on.
Ramesh sir, sorry to disturb.
One more.
Yes.
The right to audit clause should be mandatorily inserted, and the audit should be a surprise audit.
Okay, that see, it all depends on, right? It can be a surprise audit also, but audit, as you and me know, it's a planned audit. The definition of audit per se, okay, and from our management system perspective, I'm talking about. It can be a surprise audit. You can tell them, right?
Sir, audit is always a planned one, sir.
That's all. That's what I'm saying.
If it is surprise, I think it's called inspection or something like that.
So audit, by the definition of 19011 also, it's a planned activity. And audit is not to find the fault, as you and me know. Audit is to make sure that we are adhering to the system. So it's a positive way of looking at it. So I have a contract with them, so I'm going to look at them. Are you taking care of it, etc. That's what I will leave it here. Whether you wanted to invoke a surprise audit, but ensure that you have a right to audit the clause at regular intervals. Yeah.
Ramesh sir, one
There
more
is a
point.
notice also, sir.
See, many of
Always there
these,
is a notice.
in many of these
You
cases,
have
what
to
happens
provide a
when
notice, at least 1 week notice or 2 week notice.
Yeah. Absolutely. That's why it's a planned.
That clause is always there in the agreement. Even you have a right to audit.
Yes, sir. Yeah, carry on. Subhash, sir, please go ahead.
one more. Yeah. I hope I'm audible.
Yes, please, sir.
Okay. See, many of these cases where these kind of camps or these things are held,
Yeah.
the presence of international organizations, there are many cases they collect all this data and fill their own research databases and all these things, right?
Yeah.
So I think one has to especially take care of any international data transfers that might be happening for purpose of feeding in research data of those multinational organizations. Something for that proper consent, notice and consent of that specific activity got to be taken in a different way.
Correct. Absolutely. We will touch upon maybe that another slide talks about consent from every person who is, and again, privacy notice. Already we talked about it. Yeah. Shall I go ahead to the next slide, please? Individuals involved, we talked about national India as well as international volunteers coming in. Thousands of villages are there. Students are also getting covered. Whether the individual, somebody talked about it, I think Mahesh, if I'm right, whether they are aware of DPDP requirement because they are handling the data, right? Counter to counter, they are the entry point. So obviously they need to be aware of, and whether these volunteers, whether they have signed that NDA and with whom. Maybe JV Hospital is organizing or Disha Foundation, and both of them could be a joint data fiduciary. So always the contract need to be in place with everybody. Make sure that before the camp starts, all these processes are in place. And what are all the data getting collected because of the services what you're trying to provide? Somebody talked about it already again. I'm extremely happy. Many of the points are covered. Where it is getting stored? Is it going to be at a centralized location or each stakeholder is collecting? And who is responsible for providing the notice? Whether it is JV Hospital or Disha Foundation or insurers or volunteers, etc. We need to be very clear. And what are all the technological measures are in place, and whether any DPA assessment has been done and the results are documented, as a whole activity. We need to be careful. And users of the collected data, we already talked about it, that they are going to use it for the research purpose. As Subhas had said, there need to be a clear definition of this as part of the contract itself. And because as we know that many of the laws are allowing you to use the data if it is for a research purpose, but we need to be careful. And whether the data is in anonymized form, if it is not going to be not in an anonymized form, then whether that role-based access control is in place to access the data by all the key stakeholders. This point also somebody had raised it. So we need to look at all these things very clearly. Are we clear about that first case study? Just a kind of discussion to invoke our thought process on how from different angle we need to look at it. Let's move on to the second one, a simple one. Please take your time quickly to understand what is this case study. We will also have a discussion quickly. I will read it for you. Dr. Rajashekar has set up as a startup registered for a gaming business called Pakaday.com. What it does, the website provides for virtual avatars being created and gaming competitions to be conducted in a metaverse platform. The platform is created by an indoor-based software company called AS Systems and is shared with many clients, not only with this Pakaday.com. AS Systems has other services including software development. So second stakeholder had come in. Pakaday.com runs several free games and other subscription-based games with the financial rewards in the form of a game currency. The Pakaday can be bought for INR and balance can be converted back into INR. It can be exchanged for cryptocurrencies like Bitcoins also. Payment for you for you is the payment gateway service provided for the Pactate.com, and it offers a proposition to manage the targeted advertising developed from the insights developed analyzing the profile of the customers who use the payment gateway service in the company and with the other customers. Now another dimension, right? New vendor had come into picture along with the software company. Payment for you uses an AI algorithm developed by an AI experts. AI comes into picture, and it is created by a US based company which analyzes the behavior, right, of the people who plays the game and predicts the psychological nature of the players during the gaming, tracking their facial expressions, keystrokes, mouse movements, reactions to action gaming events, etc. Like yesterday, what we talked about in the car, right? Behavior of the driver getting collected, an IoT system maybe. It has an intelligent algorithm which offers modification of the game outcomes positively when they complete some e-commerce purchases on the advertised websites, which enhances the positive outcome of the games. Wow, it's like some hidden agenda, right? And payment for you requires you to integrate their software with the gaming activity so that they can provide effective targeted advertising and increase engagement of the gamers and the advertising revenues. Just look at the risks from the DPDPA perspective, from the DPO view. Good exercise, actually. This is totally, again, there the first one was sensitive personal info. This is purely, you have your payment gateway comes into picture, your original data, all data is going to be. Any thoughts? Same like the last one, right?
So in this one, Irshad here. So in this one, first thing that will focus on is profiling and automated decision making.
Yeah.
Because this payment for you AI, it is collecting data such as facial expressions, keystrokes, mouse movement, which we can consider as behavior environmental data, right? For creating this avatar thing.
Yeah.
So the consent data should be the user aware about the behaviors, aware about the behaviors that are being profiled at such a granular level. The first thing is that, and the second is regarding the purpose limitations, because they're collecting so much data. So, are the data that is being collected for gaming, is it repurposed for some other targeted advertising or behavioral manipulation? So that is one more perspective.
Very good.
Ramesh sir, can I add to what my colleague
Yeah,
is saying?
please go ahead.
This data is the key here. You see, if this data contains biases or reflects historical inequalities, the AI model may inadvertently learn and perpetuate these biases, which might be harmful overall.
Yeah. Look at our thoughts.
Okay.
Just have a look at it. We need to be aware whether the startup, because that's what the case study start. DPDPA provides some kind of exemptions. Be aware. And Pactate.com is the data fiduciary. What is the status of the AI systems and metaverse platform? Because these guys are using that. Whether AI systems will have that data, what is coming in over here, and that metaverse platform, are they capturing? We need to be aware. The status of the currency, right? Is it a cryptocurrency? Is it an artificial currency? We need to be aware. Are there any money laundering issues? Because it might be, right, going out also, coming in also. Payment for you is a payment gateway. How do they offer customer insights? Is there proper consent being obtained from them? Will payment for you be a data fiduciary, which it takes the DPDPA liabilities in case if any? And whether the Pactate.com and payment for you, are they a joint data fiduciary or a data processor in this context? And if yes, do they have a kind of data processing contracts in place? Can both be a data fiduciary and data processor at the same time? We need to be really look into this aspect. Is AI supplier a data fiduciary or a data processor? What kind of liabilities he or she going to have? What contracts have to be carried out between all these stakeholders? Is there any need to refer to the advisory given by the Ministry of Information Technology? I think March 4th reference we are referring here. So just look into all these things, right? With this, I will also
One thing has been missed in
Yes,
this.
yes,
Many of these gaming platforms have minors coming in
correct.
to play, right?
Yes, yes, obviously.
So,
You need to be careful.
I was looking at this, scanning this list to see where the minor thing
Correct,
is involved
correct,
here or
correct,
not. It is
correct,
not.
correct. No, no, point taken. We need to have, obviously. See, that's what we, applicability, all these things in a nutshell, right, Subha sir? So, who are all your data subjects? We need to be careful. Whether,
Sir, you are referring to this money laundering issues. Is there any relation between this DPDPA and money laundering issues?
I think if I'm right, we are looking at from other laws, maybe Information Technology Act again.
Comprehensively. Okay.
Yes, yes, yes. Nothing to do. It may not be straight answer. Nothing to do with the DPDPA, but yeah.
Okay, sir. Thank you.
Because you are finally collecting, right? It can be looked into other perspectives also.
Exactly, sir. Yes.
Just one point.
Yes, Navisa.
Any processing which is unlawful is prohibited.
That's all.
So if money laundering is unlawful, then it's automatically part of DPDPA.
Perfect, sir. Thank you, sir.
Shall we go ahead, Subha sir? Third one. Just look at it. Might be easy one. We are all aware of that background verification. There is a company, HRL, engaged in manpower recruitment and contractual deployment. This conducts background verification and shortlisting of the candidates based on the given profile. Just a minute. For the customer company to conduct further interviews or select or reject the candidates. The company also places candidates on contractual basis staff augmentation when required at the client facilities. Your company is proposing to engage the services of HRL for both recruitment and contractual. What are all the risks? I think this one we are all very, very familiar, right?
Yeah. Sir, one, we have to look at the role of each, party here. Two, we will need to have a clear contracts in terms of who is responsible for what, how the profile is been handling. We have to look at aspects of because they are also kind of taking the candidate's profile. We have to see how long they are going to retain the candidate's profile. Where are going to save it? They are going to save it. Is it going to be in India, out of India? Is it going to be in their server? Is it going to be in our server? Who has the key for that?
Yeah.
Okay. That's very important. And then we also need to have a clear consent, privacy notice and clear consent, because when people are collecting information, obviously collecting from third parties, so there should be a clear consent from people to say that how the data is to be used, when it will be deleted, and so on. And I have one doubt here. Should we also go back to them and then communicate to them that we have deleted the data after a certain period of time, or should we say, like, in a privacy notice only we say that your data will be retained for 1 month and so on, and that will do? That is one question I have.
You are asking HRL or your organization with whom HRL has got a contract?
I am asking here HRL.
So that is whatever the contract we are going to have, right? You will be specifying it. Now, say for example, there are 2 to 3 use cases comes in. Look at this ways, right? Selecting the candidate I have selected. The candidate is onboarded with me. Then HRL need not have that CV. But HRL might say, I am using it for my database tomorrow. Let's say that this fellow quits your company. I might even push this candidate to some other company. So we need to be very clear. All the use cases need to be covered as part of a data process. These are all typical problems we are having. Now, rejection, same logic, whatever I said, rejection of the candidates also. Whether he should have, he should not have, whether you should have or you should not have, you will be having, obviously, because another 6 months, I don't want that candidate. So if that CV comes back within 6 months, for example, as per my company policy, I might wanted to check. Then I will not entertain, because anyway he got rejected in the first case. So for that purpose, I might retain it. So all these things need to be documented as a policy, data retention policy, and then we need to have. Now with the HRL is interesting, be with me, right? Because every organization is going through a problem in this background verification, checks and so on. But so now we need to be very, very strong. Again, relook at the contract, address all the use cases, right? Like how we have a background verification policy within our organization, process within organization, red, amber, green, when they are going to be rejected. Like that, we need to have those kind of clear issues identified, clauses identified as part of the contract. Are you with me?
Yes, sir. Yes, correct.
Yeah. And handling of the CVs within the organization is also a big issue. Big issue, right? The once when we get the CV is given by the HRL to the right person, stakeholder at HR who is handling that HR person. It might be a team even, distribution list, let's say 3 to 4 people. That means CV lands in all the 3-4 places. That CV comes to me as a business where I have requested for it. Ramesh, please find and close 5 CVs. I have got around 2,000 CVs on my laptop, I can tell you right away. Right? Now, I will forward it to my subsequently let's say 2 of my team members who are going to conduct interview. Now, they are conducting the interview. Let's say out of the 2, 1 is through. Now, whether the 2 of my team members going to delete that email from me, God only knows. They say, Ramesh, this first person is selected. Fair enough. I am conducting the final interview. I am forwarding it back to my HR person. Now, HR person, that job, her job or his job is over. She will forward it to, now Ramesh is through with him for negotiation and etc. It will go to another person. The CV goes with my recommendation. So CV again flowing. That person looks at, talks to the candidate. Excellent offer has been made. And that CV and related details could be forwarded to, let's say, admin department, legal department, IT department for onboarding, because they need to provide their services. Yes, single CV, imagine. The CV might also, let's say, if he has to travel international, immediately it goes to the visa department. They have to do, it goes to the travel department. They have to organize his travel. The same CV I'm talking about. So it's a big, we all discussed this in many of the forums. And there is no solution at this point of time. At least I worked as an auditor internally as well as external. I had not seen a foolproof system, but I think we need to put together, think about having a system to handle. And just I will move ahead to what are all the thoughts. And again, the thoughts here is just a kind of, as we all know, as Subha sir found out last, we need to handle that minors also. Obviously, you need to develop it further. So, is this coming under a legitimate use? Do I need to take the consent is the question. What is the role of the background verifier here? What consent is required at the time of shortlisting or interviewing or onboarding? And if the background verification guy is going to pick up his CV from a public domain, can he forward it to me and then can I start using it? I think last week I covered this, right? One lady asked me, why are you calling me? I don't know. I have not even applied for it. So it's always recommended wherever you are collecting. So at least you can educate your contractor to ensure that they have spoken to the candidate, they have their consent from wherever they are picking it up. Right? They are getting it from any kind of Naukri.com, fair enough. They might be having a contract, consent might be there. But if they are pulling the data from unknown resources, they need to have a kind of consent with that you can tell them. And what is the role of the contractual employees? Are they employees? Are they data processor of HRL? Or the data processor of the client company? Quite interesting question, correct? This, we always handle this. Now, what we have, as far as I know, that in the current situation, we have a master service agreement with the company where I am getting the resources, and we will be having a statement of work for each business or each purpose for which I am taking him or her. And if there are 2 things, if they are going to come on board, they will be using my processes, and hence even many of the companies provide laptop from that company, right? Not from the HRL, then you are safe. Then I'm just taking only the head from that HRL, remaining the entire process is mine, so the risk may be low. If it's going to be other way around, where I'm taking that and then the laptop or etc. is going to be provided by HRL, then I need to be double careful in terms of my IT security policies. We need to bring in all these things, right? I hope we are clear. Can I move ahead with the next one, please?
Sir, this is clear. Again, sorry, I have one last question. Same question again. Now, for the candidates rejected, okay, I'm not considering currently the candidate selected. I'm saying considering only candidates rejected. Now, the profiles are with HRL, right?
Yeah.
So HRL has a policy stating the privacy notice. They say that, I will retain your profile for 3 months. After 3 months, it will be deleted.
Correct.
Now, after 3 months, does HRL have to go back to the candidates and say that your profile was deleted, or will that note in the privacy notice will do?
I think, in my opinion, privacy notice will do. Now, with that, I think there was some same question in a different context, right?
Correct.
So, for example, somebody had given me a letter saying that it is purged a certificate, but still there could be a breach. You and me don't know. Now, if that happens, the liability belongs to you. The same answer here. Now, in the privacy notice, I would have told you, hey, so and so, I will be deleting it now. If you don't delete it, you are sitting on the risk. This is where the DPO need to look into at regular intervals, right, of that organization.
Okay.
Probably, if that is applying, say, after 4 months for another position, and the website says your profile is already with us, then that is when the lapse of the privacy breach or the lapse of the privacy notice will come into play, correct?
What is the use case?
I mean, in continuation to what we are talking.
Yeah.
So the profile of the rejected candidate is removed after 3 months.
Yeah.
Say, for example, if that candidate applies after, say, 4 months.
Correct. Again,
and the website says your profile is already with us.
Correct. Obviously, it is a violation.
It's a violation.
Because in the privacy notice, you said, I'm going to remove after 3 months.
Correct.
He is digging his own grave. He is sitting on a risk. Yes.
Yeah, just clarifying. Thanks.
Yes. Great.
No, but can they retain their data? Like, for example, if the company's policies company has a policy like, within 6 months we cannot entertain you again, and the privacy notice that we delete your profiles after 3 months. Can the company store only data like name, mobile number, and address of the employee, or claim mobile number and some unique identifier of the employee of the interviewer?
So you are obviously you don't want to retain the bigger set, and then you want to retain only the subset. Please go ahead.
Correct.
As much, see, this is exactly related to purpose limitation, data minimization.
Yes.
Right. And why should I sit on a big chunk of data? Now, however, all these things technologically you can beautifully link it and then use it, right? Instead of having that whole thing. I need the first name of the person, last name of the person, contact name or email ID, which is unique, so that I can check whether he or she had applied earlier. That's all.
Correct.
For that, I don't need their full-fledged, right? So,
yes.
But in India, I'll tell you on a lighter side, I am being referred as, my name is Ramesh Venkatraman. You call me as Ramesh, or Mr. Venkatraman, or Venkatraman Ramesh, or Venkat, or VR. There are multiple ways. These are all issues which will come up, I'll tell you. The same PII. It's not so unique. But outside India, because I am closely working with European people, there it is very simple. I don't know. It's very, very simple to address them. In our case, it's totally. Right?
Correct.
So we need to have different use cases and have technical measures to. But I really like your idea. Why are you wanted to have that whole superset, have only a subset through which you can handle it? Please handle it. Beautiful.
Yes.
Great. Go to the next one. Please look at it. Indian Fashions is a leading producer of fashion garments and beauty products, and makes retail sales through e-commerce websites. E-commerce website comes into picture. And I'm sure Mr. Navi would have already talked about, right? When we talk about the process inventory, HR as a process, email as a process, website as a process, right? So link up, because there are lots of data coming in, and also maintains a company-owned showrooms besides third-party retail showrooms, again, multidimensional. All showrooms are equipped with an AI-enabled mirror, which provides a feedback on the use of the beauty of the products, which is shown on the body of the user. The photograph sensitive information, be aware, is also sent to the customer through an app, or it's going to travel through internet to enable him or her to have the experience of how do I look? Now, what are all the rights of the customer under DPDPA 2023 which needs to be factored before installing the magic mirror? Because you are capturing the sensitive data. Just think about it. Yeah?
So Ramesh sir, first of all, consent should be taken. It's Indrajit. First
Yeah.
of all, consent should be taken from the user, and the data parameters like whether the first name, last name, what exactly the person will be taken, whether it will be a retina or the facial expression. So those points needs to be mentioned in the consent that those are the data sets which will be collected. Second of all, where the location of the data will be, means whether it will be stored in India or it will be outside, that thing should be looked at.
Yeah. Any other thoughts?
So the data might be shared with third parties, as in KI vendors are involved, right?
Yeah,
So
yeah.
that needs to be looked at as well.
Just look at. Does it involve sensitive information processing? Right? Obviously, minor data, women especially, AI-enabled digital mirror. Who wants the software? Is it still that AI guys who developed it who gave it to me? Or is it going to be in their platform? Still my data is going to reside? What is the data storage policy? How long? Right? Retention policy. And again, access to those, etc. we need to think about. And hence, is it possible for the misuse of photographs? Right? We know.
Another thing, Ramesh sir, is about these photographs can be misused for deep fakes
Yeah.
and put on social
Yes.
media sites. That's a
Yes.
huge risk.
Yes, and hence, what is your storage policy? Again, even though I have not put in here, we need to think about all that access control in place, PIM is in place, data encryption is in place, right? When you are, sending it, let's say, who wants the software? If it is going to be a SaaS platform, then I need to enable my TLS 1.2 because it's going to run through there. All these things we need to think about it. Yeah, and if it is obviously minors data, again, Guardian comes into picture, verification of age comes into picture, and not only that, at the time of he becomes major, she becomes manager, I need to have a process again. So, very interesting. Next one, Child Welfare Authority. Notice you have got it. This is quite interesting. You have received a notice from a Child Welfare Authority that the authorities have received complaints that your e-commerce platform is being used by minors to purchase the products, which they are available for consumption only by adults. Right? Very interesting case study. The authority has asked you to showcase why penal action should not be initiated against you for selling the prohibited goods to the minors. Your CEO has called for an urgent meeting on how to respond to this notice by the authority. The marketing manager says that he is not aware of how they can identify whether their buyer is a minor or not. CEO turns it to the compliance officer, you, to explain how the company can introduce a techno-legal control to enable that minors are filtered out before every e-commerce activity, before every purchase or sale, and at least for the prohibited products. What do you think that you would be, from your perspective as a compliance officer, you would recommend technological measures is the point. What we need to take care of, which are all the entry points we need to take care of.
Uploading a digital or masked Aadhaar as a basis.
Yeah.
That can be a starting point where we can filter out the minors.
Very good. Okay.
Sign up onto your web page. Sign up onto your e-commerce platform.
Before every transaction.
Yes.
Notice and consent, and at the time of obtaining consent, checking whether the age of the guy providing the consent is above 18 or below 18, and this also have to be added with a little bit more due diligence. I mean, you can't take the statement at the face, but at least some additional due diligence will have to be demonstrated, that you're not blindly trusting the person.
Correct.
And I think a balance of customer friendliness would be that, you can those items which are prohibited to be sold to minors, no?
Yeah.
In the product catalog, from a technology point of view, I think it would be important to put it in the product catalog. And see, it would be an overkill to ask for each and every single customer, but based on the item that have been put into the cart, right?
Yes,
The
yes.
software can decide whether the cart contains
Oh,
anything which
beautiful.
is prohibited or.
Beautiful.
And if it
Beautiful.
is there, then there can be an additional confirmation or something like that that can be given. That it will be kind of a good techno-legal thing, so
Excellent,
that because
sir.
all
Excellent.
of this is got to be you're balancing out customer experience with compliance, right?
Yes, yes. Very good. And that is what CEO is asking. Can you please help me at least with the prohibited products to start with?
Correct,
Because that is what is going to take me tall.
Yeah.
Right? That authority is coming in. Now, if you wanted to, there are lots of regulations coming into picture.
So a product catalog should contain any items which are prohibited for minors or something, and accordingly, if it is added to the basket that point in time, additional triggers can be activated, right?
Correct. So, because every control measures is also going to cost you and me, and it is also going to cost the displeasure to the user. So that balancing activity need to be done. And hence, we have to think of some kind of new ways in which we can at least take care of to start with. Some of the things, how to set up a verifiable consent system for identifying the minors and identifying the guardians, how to get the consent of the guardians, and how to revoke the consent after the minor attains the majority. All these things, apart from regular, right, technological measures, what you and me need to really implement it for an e-commerce website. Right, this is just only a top few. Moving on to next one. Just look at it. Your company is a national network of diagnostic services with millions of patients' health data, sensitive data, available on the cloud. Very good. There are over 50 centers across the country. All of them can access the cloud and the previous data of the customer based on a unique ID. A few days back, your security team had fought off some ransomware attack on one of the diagnostic centers in Calcutta by restoring the data from the disaster recovery facilities. The newspapers today have reported that a huge chunk of personal data of your customers reported to be available on the dark web. Your CEO calls for a discussion on the actions to be taken and a report on the possible consequences. And you are the CISO and DPO designated the company. What we should really think about the step actions to be taken immediately and draft a press statement to be released. This is a different case study. Think about even DPDPA, data breach notification. What kind of process we need to have, right? When are we going to? I hope we all clear, right? Even in GDPR, you have 72 hours from the time of something has been identified as a breach, and you can even do that initial reporting to understand. If you need more time, you can always tell the authority that this is the current state of report and we are still looking at it, because sometimes it could be false positive. It cannot be a breach also. So think about all these things is what we say. First of all, is there a data breach? You don't have to press the panic button immediately. Many of the times we just pressing it. Is the data breach reported to all the data principals of all the units? First of all, it is the data breach. That's what HIPAA also talks about, as you and me know. Do a proper investigation, right? And HIPAA also gives you some kind of leverage that if it is only above 500 data principal sets have been affected, then you need to go back. Otherwise, you don't have to worry about it. You can simply talk to your OCO office, if I'm right. The same way here. First of all, it's a breach. We need to be. Can each unit be considered as a different data fiduciary? We are talking about 50 different units, right? Because each one may be having their own data, or is the data available in a centralized location? We need to be clear. Should the report be sent to the data protection board and also to certain, we need to be aware of the requirements and what is the time limit for sending the report as prescribed by for data protection board. What should be the information shared in the report? Obviously, right? What had happened, when it had happened, what kind of measures already in place. You need to go back with a strong report to give all the actions taken or proposed actions in place. That's exactly GDPR also talks about it. Okay. With this, we'll take one more. Bandhan Hospitals. Navi sir, what time is their break, Navi sir?
is passed actually.
Okay, just give me 5 minutes. I will stop here. And team, I will share all these things back along with the 2 more, which you have to do. As I told you, please do a thorough job because you might be getting 10% of your final score from the assignments. Okay. We will stop here. Please forgive me. Bandhan Hospitals is a 500-bed hospitals which has its own diagnostic center, pharmacy, nurse training, medical college, and a research center with a DNA laboratory. It was established 3 decades back and has been storing data up to 2001. So much legacy data we are talking about. And in a manual form, and thereafter digitalized their operation. Thereafter digitized the operations. Now, if this manual form data is going to be digitized, be with me, then as we all know, it comes under DPDPA. We need to be very clear. Bandhan, the hospital engages in-house doctors on employment and also several visiting doctors who provide consultancy at the hospital during the specified visiting hours and also conduct surgeries by appointment. So there are full-time employees, there are consultants coming in. Hospital also refers cases and reports to other specialists for opinion. Wow, third dimension. Full-time doctors, consultants, and some subject matter experts or specialists for opinion. And also operating a robotic surgery division where foreign doctors are also conduct surgery through robotic arms. 4 different people coming in. Surgeons also practice on an experimental basis, live patient surgeries through 3D simulated digital twin of the patient's organs, and successful results are considered as a validation of the hypothesis. The consulting doctors want to share their patients' information in their friends and professional networks, both for research purpose as a best practice sharing and for otherwise. What are the precautions Bandhan hospitals have to take to meet its responsibilities as a data fiduciary? What are all the responsibilities of the consulting doctors vis-a-vis employee doctors? What are all the responsibilities of the hospital in obtaining the patient consent both for legacy and prospective data? The last three are the questions. Very interesting case study. Can you apply your mind, think about, and all are sensitive info as we know. Yeah. I think all of you have become tired. I think I'm really sorry. We will stop here. I'll just participate, please. Anybody?
Notice and consent, obviously.
Yeah, plays a vital role. Yeah.
Data sharing with third parties.
Very good.
Contract doctors agreement should contain data protection agreement clauses.
You are talking about the consulting doctors versus employee doctors.
Consulting doctors, yeah. Consulting doctors, typically they're not employees, so there is a data protection agreement there.
Superb.
By holding them responsible for information security for the data that is shared with them.
Excellent,
right?
Excellent.
Then foreign surgeons, for example, that is foreign surgeons is a little tricky part. Because you might be sharing data. If we are sharing data and sending the data outside, right, then they have to, whatever the due diligence requirements of DPDPA, they have to comply with that also.
Right.
Because the 3D simulated digital twin, right? The digital twin, you need to have consent of the patient for creating the simulated digital twins in the first place.
Obviously,
right?
Yes.
Separately, the digital twin is also there, and again, the liability issue would come here. Say, for example, the digital twin is created by the hospital. Right?
Yeah.
What if the digital twin has been incorrectly created and false positive, false negative kind of a thing?
Yes.
The surgery is successful on the digital twin, but let us say for some reason it fails on the real one. Right?
Yes, sir.
So who's responsible for any such faults? That is an important one.
Yes.
Right?
Very nice. And also that legacy data, we need to be careful. So
legacy data.
Since 2001. And also you are talking about whether it is going to be shared with the medical college, research center, with the pharmacy, with the nurse training, so much. Because nurse training, this data could be shared as to teach them, right? We don't know. So we need to be careful. So look at
Ramesh sir, just one thing, Subbu sir, very nice. See, I think these are very protected data and very sensitive because
Yes.
health information.
Yeah.
I think reasonable and adequate security measures must be there. Otherwise, there will be some form of leakage.
Correct.
And once they leak the things, entire thing will go into a turmoil. So
Correct.
I think RSM is very much needed in this scenario.
Yes, sir. Very much. Obviously. See, we always say, right, privacy is a concept. It can be implemented only with the help of security practices in place. So anything we talk about, right, technical measures, that's why any framework, whether it is a NIST framework or 27,000, etc. And hospital is a significant data fiduciary, obviously handling large volumes of data. And the case study itself says in 2001, and sensitive personal data, health related data. How to handle manual data versus the digital data? How to handle the legacy data consent? Very good question. Because how to go back now, right? In the manual form that time, if they had taken the consent, very good, I can digitize it, fair enough. If they have not, we don't know really. And our consulting doctors again becoming a joint data fiduciaries because they might be holding the data, sharing, private to the data. As Subhas sir said, there need to be a strong NDS need to be placed, a strong data protection contracts need to be in place, and so on. What is the status of the robotic surgery system and the DPDPA part of which is installed in the hospital and part in the doctor's premises? That means the data is going to be available in both the places. So there need to be a clear understanding and contract. What is the status of the decision made through the simulated surgeries? Subhas sir already talked about it. You need to, again, harm probably from that perspective, we need to look at it. Is it attributable to the doctor or to the AI or to the manufacturer system and so on? We need to have a strong DPIA in place and related contracts to be in place. I think there is one more case study. We already talked about it yesterday. I will stop here. You take a break for 15 minutes or 10 minutes, as Navi sir said. Hope this was useful. I will be sharing this with other two, which you guys need to do as part of your program.
Now, we will go into this full framework of DGPSI, which has got 50 different model specifications. The main difference between the DGPSI Lite and this is DGPSI Lite, each of the 36 implementation specifications are directly related to different sections of the Act, and therefore you can say it is directly related clause by clause to the legal compliance required. Now, this full implementation tries to expand this legal compliance into certain governance issues, so that it will be having a bigger scope. So what we have tried to do is the entire 50 module implementation specifications are divided into 5 different responsibility centers. The first responsibility center is the top management itself, which is represented, let us say, by the governance committee. So there will be 15 of the implementation specifications. We feel that it should be handled at this level. DPO will handle about 17 of the implementation specifications. Legal and HR should handle at least 5 of these, and technology will handle about 8 of these. So what it essentially means is that DPDPA compliance through the DGPSI full system has got only 8 implementation specifications for the technology department, whereas many times we think the technology department is responsible for the entire compliance. Of course, this 8 technology aspects itself may contain some multiple sub-components, so it can be little more than the number 8, but basically these are the top line requirements for each of the responsibility centers. Now, these responsibility centers are important for the DTS calculation also. Now, generally, we feel that in any company, each company has got its own, say, organizational structure, so it may differ. But one organization structure which we think should be considered is to have the DPO directly interact with a governance committee which consists of many other CXOs, which of course is, you can say, as a constituent of the board. In many big companies, it is difficult to make even the DPO directly go into the board because board may contain a lot of outside people. So they may be little less accessible, and they will be available only once in 3 months or something like that. So normally, the company secretary reports to the board, the statutory auditor reports to the board, and the data auditor of DPDPA also will directly report to the board. Now, the CXO group, which consists of the CISO, CTO, CCO, R&D, Chief Data Officer, HR Officer, Finance Officer, Marketing Officer, and also CRO if it is there. All these people should be put together in the data governance group. To this, a member of the board also should be available, and that member should ideally be an independent director, and he should also be the chairperson of that board. And the DPO will be also part of that group, and he will be the person who is like a secretary of this particular entity, or the you can say steering group or whatever is that. If you already have a steering group for IS, keep that separately. Create a separate steering group for this particular DPDPA compliance. The DPO himself may be internally assisted by at least 3 categories of people. One is the person who is the assigned HR coordinator, because in every company, including manufacturing companies, HR is one of the biggest functions which require DPDPA compliance. The legal coordinator will be a representative from the legal department who has to assist the DPO. Then the other department, we have called them as process controllers. They will all be like internal privacy by design coordinators, and they will also have to be together represented by some assistant to the DPO, so that the DPO is not left high and dry as a single person who is having all the responsibilities, but the work is so overwhelming that he may lose control on the whole issue unless he is provided adequate organizational support. This is, of course, a suggestion. Each company can have its own implementation structure. Now, from the perspective of DGPSI, the basic requirements of compliance are covered by the DGPSI Lite, and this 50 model implementation specifications are consisting of a larger set. Now, these are called model implementation specifications because they have been identified as perhaps like a wish list. It has to be like this. Now, out of this, it is possible for the company to filter out a few of the model implementation specifications and generate an adopted implementation list of specifications, which will be less than 50. Now, for this purpose, there has to be a deviation justification document, which the top management takes responsibility for. And the difference between the model implementation specification and the adopted implementation specification represents the risk absorption capacity of the organization. So it is kept like this so that there will be some flexibility in the implementation. I am sure you have a similar applicability statement of applicability in the ISO segment also. Here we expect this deviation justification document to be actually signed off top management, and what is adopted is what becomes the implementation charter. So when the operation team uses that implementation charter and implements, and subsequently when an audit is conducted, the auditor takes this as a reference document under which he will try to audit. So whatever is left out here, which has to reflect in the gap assessment, which the auditor himself may do. Auditor will start his work with a gap assessment. In that gap assessment, all the 50 model implementation specifications will be looked at. Then he will find that actual adoption is for less than this 50. So he has to reconcile that with this deviation justification document. And then he goes ahead to look at how the adopted implementation specification is implemented by the organization. Now, we have the system of data trust score, which should reflect on the maturity of the implementation. And for this purpose, we recommend usage of the model implementation specifications, not the adopted implementation specification. Now here, however, for the 50 implementation specification, for each of them, we try to make an assessment between 1 to 10, which means there will be total 500 points in the whole system. And then we create an index value, which can represent the DTS of the organization for the particular audit scenario. Of course, DTS score requires a thorough audit over all the 50 parameters which are there in the model implementation specifications. But when we are trying to get this final index, we are trying to actually recognize 5 responsibility centers and look at this aggregation of points in this respective responsibility center category, and then assign some weightages and then aggregate it. Okay, this is a simplified model which we are adopting today. As we go forward in the future years, perhaps things may further be fine-tuned. Okay, currently we are doing this kind of an activity. Now, these 50 model specifications, which are divided into management 15 and then DPO and others, basically they look like these statements, which are similar in any other, you can say, the framework. For example, it will say as a management responsibility, organization shall designate or appoint a compliance manager or a DPO, etc., with external consultancy as might be required. So leadership and accountability is one of the first things which the management has to decide, not leave it to the DPO. So constitution of the data governance and protection system committee is also a part of this management responsibility. Then it should perhaps define how this will function, how frequently they meet, etc. And then the appointment of data auditor is also the management responsibility. And then exception handling policy. That is all said and done. There will always be a requirement for some exceptions due to some exigencies. And unless you make provision for that, then the rules and regulations fixed as a policy itself becomes a hindrance to the company in some form, which should not happen. So there has to be an exception handling policy, and it has to be having its checks and balances so that it will not be misused. Okay. Then this distributed responsibility, where we say that the responsibility of data protection is actually shared by a number of people in the organization, is also a major organizational requirement, and therefore it is considered part of the management's responsibility to define this distributed responsibility. This distributed responsibility is very much important for this unstructured data handling. And because whenever we have a situation where data gets distributed to multiple people, Ramesh was telling in the previous HR instance that the CV gets distributed to 4 or 5 levels within the organization. We don't know what happens after the exercise is over. By calling every employee a DPO within his domain, we are expecting that it is that employee who has to decide that I have a personal data today because I have to do some interview. Now, after the interview is over, I have given my views. Maybe I don't require it, and he has to either return it to the custodian of the data, and while he does it, he also has to delete from his records. Therefore, no person other than the main custodian of data should be having multiple instances of data. If that multiple instances are there, then data eraser requests, it is very difficult to implement. And in terms of technology, unless you have a centralized database where there is an inventory of personal data, and that inventory carries a specific unique ID for the personal data, again, it becomes difficult to put in practice the data eraser data correction kind of activities. Otherwise, you will have one data in one department, another data in another department. You can see that today most of the banks have this problem that data is not synchronized across different departments, so that they always find that even after providing the latest updated data, you will continue to receive reminders and other things. That's all a case for correction through this distributed responsibility and centralized data management scenario. Okay. Now, the definition of a significant data fiduciary, whether we are to be considered as significant data fiduciary, again, is a management decisions. Then creating legitimate use policy for different processes and defining the use of exemptions. We feel that the top management has to put its stamp of approval. Okay. Then if there is a need for data valuation, that also is something which the management has to decide. Okay. Then new business prospecting, which is the marketing activity. See, to introduce DPDPA compliance at this stage means that when you are negotiating with a prospective client, if that business involves processing of personal data, reference is required to be made to the DPDPA to understand the consequences, and it will have to reflect in whether we should accept the business or refuse the business. If we are accepting the business, whether it should be priced at our normal rate or at a higher rate. All these decisions will have to be taken right at the time of accepting the new business prospect. So management has to define that marketing managers cannot go on a spree of signing contracts and then coming back and telling the DPO that I have already signed this contract. Please do this at this particular, and also tell the finance manager that I have agreed for this particular kind of rate or something like that. So that decision that the marketing manager, along with the consultation of the DPO, has to agree for new business is again a management decision which should be put in place. Then when third-party data processors are there, including cloud resources, the organization should establish the policy of how we use these data processors and what kind of responsibilities we expect them to fulfill, get appropriate assurances, and then, of course, where the assurances are not verifiable with audits, and if indemnities are not sufficient, whatever is left over becomes the absorbed risk. So you try your best to get an indemnity and then assurances, but rest of it, whatever remains, becomes residual risk which has to be absorbed. Then organization has to establish a system of monitoring the relationship with CERTIN, relationship with Data Protection Board. Who will handle that? How it will be handled is again a management issue. That is all the external organizations management. Okay. Then if we come to the policy of data monetization, we are expecting that the organization will develop a policy called data monetization policy. That is, we understand that in the current economic world, data is monetized because otherwise companies may not exist. What law expects is whatever you do, take a proper consent. So if a data principal is willing to give you consent for monetization, it is fine. But you should ask for that. Now today, when we are talking of AI or anything like that, we are many times, we monetize without informing the data principal. That should be avoided. So there has to be a data monetization policy which will inform the data principal that I am using your data with or without identity. Maybe for my data analytics, I am not using your identity. I am just aggregating. And therefore, there should be no objection. In fact, when personal data is converted into anonymized data, it ceases to be the personal data. It becomes a non-personal data. But in between, there are categories of partially, you can say de-identified data, where it is preferable to have the consent for monetization. So there should be a data monetization policy to help the marketing people be satisfied with the implementation of the act without affecting their current activity. Then as far as the digital presence is concerned, both on the web as well as on the app, there has to be specific policies. This will apply to wearables, IoTs, and there will be intellectual property issues. Then whenever you use LLMs, the possibility that the data which you feed in there may be sent to the back end by the LLM for learning purpose. So these issues will have to be supported by policy. I am not saying nothing is permitted or something like that. The law is very clear that if there is an appropriate consent, you are free to make use of it. Now, what is appropriate? There has to be a risk assessment. There should be an information or the notice to the data principal that we are using it for such purpose. This is possibly the consequences of that. Please give me the permission. This is the reward which I am going to give. For example, in the drug manufacturing industry, we do a lot of, let us say, experimentation on humans of new drugs, but we still do it as with a consent. So if we can do it in a life-threatening situation like that, we should be able to monetize data also in a TPDPA compliant manner. Then the management has to take a view on identifying the risks of penalty or punishments under other laws like the ITA 2000, IPC or CRPC or the new versions of that, and set the ball rolling. So these are all the management decisions which cannot be taken by the DPO. We feel DGPSI has to consider this also. Now, coming to the DPO, the 17 provisions, they are more directly linked to the DPO's responsibility, like this legacy personal data consent, then the data auditing policies, and all these regular things which we have already covered under the DGPSI Lite. Okay. I will then move to the legal and HR, which are additional. Now, there are certain things which we normally expect the DPO to do, but I feel it should be done by the legal department, like this establishing the policy for nomination. It is very difficult for us to expect the IT professional who is working as a DPO to understand all the nuances of nomination, because nomination may result in actually disputes. At some point of time when you want to settle the claim, you may suddenly receive an email from somebody saying that I am the legal heir, you cannot transfer this property to so and so. Now, how do we handle that? And if we handle that without proper, let us say, precautions, are we going to open a new legal risk? Is something which requires a legal knowledge to address. Therefore, I feel that nomination policy should be established by the legal department. So, for example, when you say, when do you consider a person as deceased or reported deceased? Because there could be a lot of phishing which can happen. Okay, so we have to have the policy for registering the nomination, and then when there are disputes from claims, how to handle that. These are things which are the domain of pure legal professionals. Similarly, grievance redressal has to be handled by the legal department. Then policy for this handling of the verification of the minor's age. For example, we normally say 18 years is the period of a person becoming a major, but there are instances where a person might have been appointed a legal guardian before he turns 18, and such a person will become a major only after 21 years, perhaps. Okay, so there could be some differences. And now the government is talking of opening bank accounts for people with 10 years. And they are also talking of providing checking facility, etc. So RBI is trying to actually challenge the DPDPA as far as the handling of the minors data is concerned. If you are a bank, if you are confronted with compliance with DPDPA on the one hand and RFPI guidelines on the other hand, how do you ensure that compliance is much more than what an ordinary legal department can handle in the bank also? Okay, so I'm sure that initially banks will make lots of mistakes here and people like us will be crying out. I have actually written about it recently. So there is a need for the legal department to get involved in this kind of a thing, and what is behavioral monitoring and how do we handle disabled persons. These are all issues which the legal department has to handle. Then the contracts. As we have seen when we are discussing about these cases also, that in many cases, there are multiple parties involved in the case, and then each party has a contract with the party above them or below them, and everything is legal contract. So the legal people or compliance department or the legal department needs to look at all the contracts which are driving the company's activities, and that can only be done by the legal department, not by the DPO. So therefore, the legal department, we have assigned at least 5 of the implementation specifications. Similarly, when we come to HR, we are looking at this compliance, and 5 specific implementation specifications are assigned to the HR department. For example, having an inventory of people, and this inventory of people with assigned responsibilities. For example, they have to be linked with a certain process, and they have to accept distributed responsibility. Somebody may not say that I was recruited as a developer and now you want me to be a DPO. It's not possible. I'm not a legal person. Okay, so if that is there, then we have to ask for policy changes and say that no, from now onwards, development will include, it is not only security by design, it is DPDPA compliance by design. Therefore, you need to be aware of DPDPA and you need to take responsibilities. When you are doing the coding, I don't know what is the coding. If the coding has some, say, bugs or even say backdoors, then I as a DPO will be responsible for that. That is not acceptable. Therefore, every employee of an organization within his domain of activity, we consider him responsible for DPDPA compliance, and therefore the HR policies, including your employment contracts, need to be supplemented with the DPDPA upgradation. Okay, so now is the time when the company is adopting this DPDPA compliance. It is the time you give a notice to all the employees that your whatever employment contract is there, these are the additional clauses which we would like to add. This is mandatory. Okay. It can be in the form of an ethical this thing or whatever is that. In fact, if in all the things which I draft, I also add a clause that the employee will be loyal to the company and the nation, okay, against even the religion. So I don't want people to say that my religion is ahead of my company or ahead of my nation. And we suggest such kind of things to be incorporated in the HR policy. Therefore, HR policies has got a lot of modifications to be done, and that has to be handled by the HR. Then we call this HR policy as an augmented HR policy because it mandates the compliance, including duties, sanctions, and incentives. If you want, you give incentives, but the sanctions and the prescription of duties is part of that. Then when we talk of whistleblower policy, this also is mandatory in this HR policy, and obviously HR has to organize that. Then your accepted usage policy, please check whether it is fine-tuned to the requirement of DPDPB. So therefore, HR, we have allocated these 5, and what leaves this is about 8 implementation specifications for the technology people But within this, it will be development of the inventory of processors, inventory of processors, and what should be the contents of that, and then creating the inventory register. All these things come under the IT department, and we expect that there is a centralized database with the master data management ID, which is unique. And when you take a data set, initially the data is not identifiable. It has got some data elements, and when couple of data elements come together, they become identifiable. So this transition from the zeros and ones in being in a chaotic state in the particular environment, gradually coming together and forming data elements, and certain data elements coming together forming personal data sets. This is a gradual technology process, and we need to have a process to capture this. So we may have certain in building the data inventory, we have that intermediate stage where data elements are all put together, and then you run a data analytics software on that, and then from there extract the identifiable personal data and then move it to another. So this kind of technology architecture needs to be the responsibility of the IT department. Okay. Then the organization shall set up the pseudonymization and anonymization. Is a very important aspect. It should be used whenever data is transferred out of the custody of the organization to any outsider, whether it is a cross-border transfer or transfer to a data principal within India. Okay. Then security controls obviously is the responsibility of the technology department. Then transit of data across jurisdictional borders, then disaster recovery, business continuity, then classification of the data. Okay, these are all the responsibilities of the technology department. So this 50 implementation specifications are spread across these 5 responsibility centers. While DGPSI Lite can be sufficient for SMEs, DGPSI Full is recommended for larger organizations, and it can also be used for DTS implementation. Now, I will briefly talk about this DTS, how we lead to the DTS. In the DGPSI implementation, first we have the gap assessment. Gap assessment may be done by the auditor, or he may start with the gap assessment done by somebody else recently or something like that. Then based on the gap assessment, the management will take a look and then convert it into the implementation charter. As I told you, gap assessment is based on the model implementation specification. The implementation charter will be the one which is the adopted implementation specification, in which the difference represents the risk absorption capacity, which only the top management has got the right to implement, not even the DPO. DPO cannot fix the risk absorption capacity of his organization. Only the board can do that. Then, when we are talking of data DTS calculation, the first step is during the audit, the auditor provides a rating for each of the 50 implementation specifications on a scale of 1 to 10. This is a subjective evaluation which has to be later on converted into an objective evaluation. Each auditor has to fix his own method of how he tries to make a subjective evaluation and then assign whether it is 3, 4, 5, whatever is the objective number you have to assign to that particular maturity of the implementation. Okay, that is the first step. Now, next step, we have talked of 5 groups, and for each group, yes, total score will have to be computed. Okay, then each group-wise score should be converted into a percentage of the maximum permissible group total. For example, management 150, 15 implementation specifications are there. 150 is the maximum score. DPO is 170, like that. Now, if you assign, say, 50 out of 150 for management, we are talking of within that group, it is 50 out of 150, that is 30% or whatever is that, okay, 33%, okay. So each group, you try to arrive at this kind of group-wise maturity as compared to the maximum available thing. Then we assign a weightage to each of the groups and convert this group total into certain weighted score, which will be aggregated to form the total weighted score, which is the DTS of the organization. Okay. Now, we hope that over a period of time, if DTS has been calculated, then instead of representing DTS as one single number, you can also represent it as a trend over the previous years, like DTS is 60 plus or 60 minus, indicating whether it's an increasing trend compared to the previous year or decreasing trend. These are some suggestions which we are giving to our auditors, but auditors can develop their own systems. Even this assessment of 1 to 10, we are suggesting that you can use some model. I personally, these are all things which I personally use, which you may take it or improve upon it. I would like all of you to remember one thing. This entire DGPSI is a system which is being developed by the professionals in the particular area. And all of you are stakeholders in this, and all of you can participate in making this a more useful tool for the companies and the professionals. See, this is not like an ISO where you have to go to the international board to get approvals for any suggestions or something like that. We have the access, we have the flexibility to make improvements as and when required. Therefore, all of you should feel proud to be part of the development of this indigenous system. So please look at it like that. But right now we are presenting something which is a basic design idea. It can always be improved. So in that context, when I assign these 10 points, I look at this kind of a grid. That is, the first 3 points will be based on whether necessary policies are in place, because this is something on which the management has 100% control. I can develop the policies, whether it is accepted by the employees, whether it's implemented by this thing, but having the policies is something which is at my control. So that is the first thing which I expect, and I try to give up to 3 points for the policy implementation. Then technology controls is also partially under my control. So another 4 points we assign to the technology controls. Then the balance 3 points, this represents the resilience in the sense that whether the company has is in a position to ensure that there is repeatability of the processes, and whether the employees have built in a privacy culture so that we can expect that what I see today is likely to be considered as repeatable over a period of time. So if I am making any particular audit as of today, maybe only 7 points is the maximum, because resilience can only be measured after 1 year or after 2 years. Okay, so presently, if some organization gets only say 4, 5, or 6, or out of the 7, it will be difficult to get even 7. So less than that, it doesn't matter that it doesn't mean that the company has actually failed the audit. See, success or failure in audit is based on the model, adapted implementation specification, where the auditor will look at the implementation charter and say whether you have got adequate measures to meet what you yourself has put as your target. Now, this assessment is more like a kind of an ideal situation. We are looking at model implementation specification, and I am not expecting 100% implementation in any particular case. So if some organization is not able to achieve 100 as the DTS score, it gets only 35, 40 or something like that. It is not a failure. It is only a indication of the maturity as we see today. It can be used for further improvement, and maybe another auditor may look at it slightly different. So, but that is how we expect DTS to develop over a period of time. For implementation of this, we are looking at a certification system where FDPPA will be the main certification body, and we will be accrediting certain certification bodies which will interact with the auditee organization. And the DGPMS auditor is the person with the right kind of, say, qualification, which we today say CDPODA. He has to be leading the audit. He will interact with the auditee organization as on behalf of the accredited certification body and conduct the audit. The auditee organization can take the assistance of a separate DGPMS consultant for preparing to be audited if it is necessary. Okay, so FDPPI accredits the certification body. There are a few certification bodies which we started with earlier, but most of the contracts have expired. Now, after this DPDPA Act and rules have come, and we have introduced the C.DPO.DA, we have to actually re-accredit most of them. But this is where the professional organizations who want to be in this particular field can work. Okay, then they can take the assistance of the consultant where it is necessary. Okay. Now, DTS is presented as a number between 1 to 100, and as I told you, it can be used as a trend indicator also. So this is the DGPSI full version. The book DGPSI contains the full details. In fact, over a period of time, see, at FDPPI, I am also driving a particular activity called the AI chair. Okay, in that AI chair, we are trying to actually ensure that some kind of an automation can be built up for implementation of the DGPSI. We hope we will be able to achieve it over a period of time. So I will stop here and take any questions if it is there. Yeah. Yeah, please go ahead and tell me.
Sir, is the DGPSI that booklet is available to download, or how is it, sir? Or is a separate book?
There is a Kindle version for this. It is a separate book. The Guardians of Privacy is one book, and then this is the Guardians of Privacy. Okay, and DGPSI is a separate book. Both are available in print form. Both are available in Kindle version, which is not expensive. So you can try to make use of that.
Sure, sir. Thank you.
And I'm always available for discussions. In fact, we are prepared to actually take a mentor session if it is required between now and say maybe by tomorrow, I will be in a position to provide the video recordings of the sessions. But we would be making the video sessions available only to those of you who are taking examination at the end of May. Now, tomorrow day after, I will be issuing the participation certificates to the people who are subscribed to this program. Now, after this, it is open to you to work for a full certification by passing the examination. The examination, we hope you can take by end of May. If at all any of you want some extension and other things, you can always tell me. And those of you who register yourself for the examination, all those people who have paid for this automatically get the examination ticket. Okay, they can, without further payment, they can schedule the examination. But those of you who are actually guest invitees, if you want to take the examination, we will be having a separate fee structure for only the examination. You please take that. Only those people who take the examination, we will be sharing the videos for further discussion. The books are available, as I told you, either on the Amazon in Kindle form or in print form. You can always buy it from the links which are available. Okay, so that is the material. If you study that along with the PPTs which we have shared, I think you will be able to get through the examination. We are only expecting 40% for actually clearing. 60% is what we desire for people who want to become auditors, but 40% is the minimum. But many of the people come up to 35, 36, 37, and then they find it difficult to cross that 40%. I hope this batch will be different. And as Ramesh mentioned, one or two case studies we will leave for you to submit as an assignment. And we want to actually add certain bonus points to the examination score, so that people can have both the, answering the multiple choice questions and as well as have the experience of writing down some reports or something, making a risk assessment in a practical situation. Both will be evaluated. That is what we are trying to do for this examination. Okay.
And
So the
even this,
examination, sorry, go ahead.
no, go on.
Sir, examination will be online or how is it? And is it objective?
It will be online. You will be having 2 hours of time. And for those of you who had taken examination earlier, about 6 months back or earlier, I must say that we have very much simplified the examination. We have given more time. We have reduced the number of questions so that people are getting, though I was always telling that it is not expected that you answer all the questions. There will be more questions in the bank. You answer whatever is possible, okay? Because evaluation was based on some relative indexing. But still people used to feel that when they cannot reach the end of the examination, they used to panic. So we have now made it very, very simple, much, much simpler compared to what it was earlier. If any of you take the examination today from and you had already taken the examination earlier, you will find the difference. But it will be multiple choice questions. Each question will be having at least 5 answers, out of which more than one will be correct. And there is also a proportionate negative mark for wrong answers. Okay. But we will help you to prepare for the examination. Maybe between now and the next week or so, because after 7th, after 5th of May, I am slightly getting engaged in some other things. So between now and the next week, if you want, we can have another, including next Saturday, Sunday, another discussion if necessary for clarification of any doubts on the subjects. Okay, then we will be able to give you a small sample examination that I will try to give you after about 15-20 days, about a week prior to the you are taking the examination, so that you can be confident in taking the examination. Okay. Any other questions?
I want to ask what you clarified, sir. Thanks.
Okay.
The negative marking and the number of questions. I mean, last time that was one feedback, correct? That it never ended. I mean, and everybody felt okay, so I have not finished the exam.
Yeah, that is true. Okay, we have changed that. So, and anyway, your WhatsApp group is there. So if you need any more clarification, you can always post it there. I will try to answer it. Okay.
Sure, sir. Thanks.
Fine, sir.
So Ramesh, you want to say anything more?
Navi sir,
Yeah,
Navi
yeah,
sir.
yeah.
Sir, just had a small last question. So you said 2 hours exam, MCQ. So what would be the number of questions to attempt in this 2 hours?
It will be not more than 150 questions. So almost 1 minute per question you will get.
Okay, just wanted to get an idea.
Yeah.
Thank you, sir. Thank you so much.
Most of the questions will be something like a scenario-based questions. Okay, it will not be memory-based questions. So you will have to look at the question and answer like what you are doing in the case studies today. Okay.
More conceptual.
Conceptual. Yeah. Yeah. See, our objective is that examination is secondary. All of you are going to be the ambassadors of DGPSI, and you are also going to be DGPSI ambassadors. So we want you to actually learn this concept and assimilate it. That is more important. Okay, examination is a system which has to be there because there is no other way of evaluation. Okay.
Yes. Fully appreciate, sir. Thank you.
Okay. So, friends, if you permit, we can wind up the session today.
Yes, sir. Thanks so much for your time. I appreciate it, sir. A lot of information.
Yeah, please post your feedback on the group. You also can share it with the LinkedIn. So let us know your feedback also. Okay. Yeah.
Sure, sir.
Thank you, sir.
Thank you so much for your
Thank you, sir.